I wasn't even on the panel that made the decision in that case.
I won't hold you to it because I don't expect you to remember all these, because you've written some 700 opinions, as I recall, so I'm not going to hold you to that. But
I think it's important, though, to understand the difference between being part of a three-judge panel,
sure,
which I was not. I was not one of the decision makers in the Hammond case. I was simply a member of the court, and all of us voted whether to hear the case en banc. But I was not part of any decision in that case.
Well, the problem with permitting a, quote, manifest imbalance, unquote, that is a statistical disparity not traceable to any intentional discrimination to justify quotas or other preferential euphemisms like numerical goals, is that statistical disparities can and do often occur for many reasons other than discrimination. And it's unfair to penalize innocent persons and deny them opportunities through quotas or other preferences simply because an employer's hiring statistics are not, quote, balanced, unquote, according to some notion of statistical proportionality. It's an important issue. It's probably one of the most important issues in the future for our country. And I don't expect you to tell me how you would rule, but let me just pose a hypothetical situation to you. Suppose a small business in a major city that was majority black had never hired a black person, even though that business in over a decade had hired more than 50 people. Further, suppose that a disappointed black job applicant filed a discrimination suit, but he or she was unable to provide any direct evidence of intentional discrimination by the employer. Would such statistics standing alone, in your view, justify an inference of racial discrimination by the employer? And would that employer, in your view, to avoid expensive and protracted lawsuits that could cost hundreds of thousands of dollars, be justified in using quotas or other forms of racial preferences to eliminate the, quote, manifest imbalance, unquote, if that really is the law? And just one other question. Would a federal court be justified in such a case ordering that employer to resort to quotas or other forms of racial preferences to eliminate or reduce the, quote, manifest imbalance, unquote?
Could you repeat the question again for me?
I think I have the gist of it, Senator Cohn. Senator Hatch?
Yeah.
We have many employment discrimination cases in the court.
Right.
They come to us with a very large record of facts developed in the trial court. And then they come also with lengthy briefs on both sides. And I study those records intensely, read the arguments, have my law clerks do additional research, come armed to the teeth to the oral argument so I can ask the testing questions. So I'm always suspicious when I'm given a kind of 1, 2, 3 in hypothetical.
Sure.
I know that I've done it myself when I was a law teacher, and sometimes my students would answer to that kind of question unprepared. But I can say this. I was thinking about a particular case, one that in fact went to the Supreme Court. It was a Santa Clara Highway Department case.
I'm aware of it.
That involved one of these affirmative action programs.
That was a Johnson case.
Right. Paul Johnson was the plaintiff.
Right.
And he complained that Diane Joyce had gotten a job that he should have gotten, and it was a result of this affirmative action plan. And that was a case that was much discussed. I'll just tell you a non-legal reaction that I had to it. This was a department that had 238 positions, not one before Diane Joyce was ever held by a woman. There was an initial screening, and there were some 12 people who qualified for the job. That was further reduced till there were 7 considered well qualified for the job. And then the final selection was made. And on the point score, Paul Johnson came out slightly higher than Diane Joyce. But part of the composite score was based on a subjective test, an interview, and they were scored on the basis of this interview. And I had to think back to the days when I was in law school, and I did fine on the pen and paper tests and had good grades, and then I had interviews. And I didn't score as high as the men on the interviews. I was screened out on the basis of the interviews. So I wonder whether the kind of program that was involved in that case was no kind of preference at all, but a safeguard, a check against unconscious bias, against the unconscious bias that I think may even been conscious way back in the 50s, but in a department that has 238 positions, none of them are women, whether the slight plus, I mean, one must always recognize that there's another interest at stake, in this case, Paul Johnson, whether the employer wasn't, in fact, engaged unconsciously in denying full and equal opportunity to the women. These are very difficult cases, and each one has to be studied in its own particular context. But in that case, at least, I related back to my own experience, and any time you're involved with a subjective test, there is that concern that if you are a member of the group that has up until now been left out, is it that the person who is conducting the interview finds you unfamiliar, slightly uncomfortable thinking about you being part of a workplace that up until then has been, say, all white, or I did want to make one comment, if you will allow me, Senator Hatch, because when you said that Brown was, that it wasn't ahead of the people, in at least one respect.
It was ahead of some of the people. There's no question about that.
I had to think about one of my wonderful colleagues, Judge Skelly Wright, who was a brave judge in New Orleans, who for 10 years tried to implement that decision. Right. And massive resistance was mounted against it. But he did what a good judge should do. He enforced the law.
Sure. The reason I brought up Dred Scott and that case is because there were whole segments of our society who were way behind, or way ahead. In the case of Dred Scott, almost all of the North was ahead. And many people in the South who refused to fight on the part of the South. In the case of Brown versus Board of Education, there were many in both areas that were way ahead and who expected and really demanded the decision that came. Well, the reason I gave you the hypothetical example I did is because I have had a lot of experience with small business people who are suffering the stings of these employment discrimination cases. The average cost of defending those cases before our 1991 Civil Rights Bill that we enacted here, which I voted for, the average cost of defense alone, just paying their attorneys to defend them, is $80,000. That was before that statute, and I suspect that cost has gone up a little bit since then. But in the 13 years, I give you that example, I did because I have great faith in you. I have known you since 1980, and I've watched what you've done, I've admired you, I have no doubt that you're a person of total equality and a person who deserves to be on the Supreme Court. But in response to the Judiciary Committee questionnaire, in the 13 years since you went on the bench in 1980, you've not hired a single black law clerk, to my knowledge, at least according to your secretary or intern out of 57 such employees that you have hired. Now, I find no fault with that, because I know that there was no desire to discriminate. Even though your court sits in the middle of a majority black city, Washington, D.C. Now, some, if they took the The broad language of Abner Mikva in that case might call that a, quote, manifest imbalance, unquote. Now, I would not suggest for a moment that quote, imbalance, unquote, resulted from any intentional discrimination on your part. The crucial point to keep in mind, however, is that when the concept of, quote, discrimination, unquote, is divorced from intent, and we rely on statistics alone, a small businessman or a woman with your record of employing minorities might find himself or herself spending hundreds of thousands of dollars to fend off discrimination suits. And that, in fact, is what's happening around this country right now. Such an employer might adopt quotas or other forms of preferences in order to avoid or avert such litigation under any number of civil or federal civil rights laws. And I'm worried about it because it's not fair to the employer, and it's not fair to the persons denied opportunities because of preferences. So naturally, I'm concerned about preferences, and I know you are, and I know that you're a very good person, but I just want to point that out because that happens every day all over this country where there is no evidence of intent. In fact, there was no evidence, no desire on the part of the employer to exclude anybody.
And I appreciate that, Senator Hatch, but I do want to say that I have tried
I know you
to, and I'm going to try harder. And if you confirm me for this job, my attractiveness to black candidates is going to improve.
Well, that's wonderful. I like that. But let me just say, you can see my point. These things are tough cases. They're difficult. There should be some evidence of intent. Now, in the case that you, in Johnson versus City of Santa Clara, your point may very well be well taken, that the oral interview was, if it had been explored in a little more depth, may have shown some intention to exclude women. And